So welcome back, everyone. I hope you're having a nice morning. I'm going to introduce myself and the lovely Lisa. If you weren't here yesterday, I want to give you a big warm welcome and say thank you for coming. My name is Caoimhe. I'm the Student Engagement Officer here at AHEAD, and a little bit about myself, I suppose, is that I was in the Student Union in NCAD for 2 years and met or learned about AHEAD while I was working in the Student Union, and I was absolutely blown away by the work that they did. Then I personally got diagnosed with a disability and went to AHEAD for a load of supports and resources, and it was amazing. And then a job was coming up in AHEAD, so I decided to apply for it, and I got the job, and now I'm running this event, which is so exciting. That's kind of everything about me. But the Power of Disability is a talk and conference that I went to when I was in the union, and I found it a huge benefit. I found it so helpful. I found it really insightful and really educating, and I'm really glad to be part of it this year in my organising role and working with Lisa alongside the Students with Disabilities Advisory Group to create the event for students by students. And I'm really looking forward to today. I hope you are too. Lisa, I'll let you introduce yourself now.
Thank you.
I'll stop talking.
Not at all. Good morning, everyone. As Caoimhe said, thank you so much for joining us for day 2. And if you were here yesterday, welcome back. So for those of you who weren't here yesterday, my name is Lisa. I'm a recently qualified primary school teacher from Maynooth University, having done my master's there. I'm also a wheelchair user, and I am also working with the Student with Disability Advisory Group on behalf of AHEAD and USI. So I'm the co-chair of that alongside James from USI. So as Caoimhe said, I'm the same. I've been to so many of these Power of Disability conferences over the years, and I really find them so empowering, and it's so lovely to have that kind of community piece, I feel, amongst disabled students, because I know oftentimes when you're a disabled student in higher education, it can be really daunting. There can be so many struggles that you feel like you're the only one going through. So it's really nice to kind of have those kind of chats and kind of realize that you're not on your own, and seeing how other people have overcome things and trying to hopefully find solutions to things that we've been going through. So it's an honor to be one of your MCs today and yesterday. And I'm really looking forward to the sessions that we have lined up for you today. So yeah, here's to a really good day.
Yeah, great. I think yesterday was a lot more personal. We heard a lot of personal experiences, and today is a bit more educational, I suppose, in terms of you're going to be learning about your rights.
Sure.
Both, sorry, I'll just change it to this. So we'll be focusing on disability rights both in Ireland and the EU today. We'll also have a student feedback session with me. That's going to be this morning, where I will have an anonymous Slido QR code on the screen where you can scan it and submit anonymous feedback. You can also submit feedback on anonymously. Is that a word? I don't know.
I think we should make it a word. This is the
Yeah,
second
I've
day.
been making words up. I've been making words up this entire conference. But yes, you can submit voluntarily or anonymously, I suppose is the right way of saying it. And we will get to some valuable feedback from that and learn what is best to do for the event next year and what will work best this time next year. And yeah, I think that is the last slide for now. So we'll do a bit of housekeeping before we start, maybe. If you want to speak a bit about language, Lisa.
Yeah, absolutely. So obviously we're really cognizant of the fact that we're working for disabled students. This is run by disabled students. As I mentioned previously, I'm here in my capacity as working with the Students with Disability Advisory Group, which is run by AHEAD and USI. So obviously we are called the Student with Disability Advisory Group. We had to come up with a name. And obviously we're cognizant of the fact that that gets into a much deeper discussion of identity first and person first language, which we are very aware of, and we're also very aware that everyone has a different relationship with their disability. So just to bear in mind that the terms disabled person or person with a disability may be used interchangeably throughout the sessions, and that's basically just to make it fair to everybody, because everyone has a different relationship with their disability, and everyone identifies a different things, which is completely valid and completely okay. So just to be aware of the fact that some people may use language that might be a little bit different to what you use and vice versa, and that's okay, and that we're open to all levels of identity and disability. So yeah.
Amazing. I'll just mention again for anyone who joined a little later than when I said we have closed captions today. You can turn them on by clicking more and then captions. I actually think, can I bring this over and show you? Can you see that?
No, I think it's just sharing your slide there.
Oh, that's so sad. Okay, well, if you click the 3 dots on the right that says more, you can click captions ... and then you can show the captions.
if you've any
Um,
anyway, you can message myself or Quiva throughout the session if you
yes,
need. So
we also have Danielle on for tech support. So if you need any help with anything, you can message Danielle. Which I actually might ask you to stop recording now for a moment, Danielle, when we start the student feedback session.
Annie, welcome back, everyone. Hope you all enjoyed the little break. We are welcomed now by Charles O'Mahony. So Charles is going to be giving us a really, really interesting presentation about understanding your rights. So Charles is a PhD at the Centre for Disability Law and Policy in University of Galway. And they were elected as president of the Irish Association of Law Teachers from 2014 to 2016. And Charles previously worked as Amnesty International Ireland's legal officer on its mental health campaign and a legal researcher for the Law Reform Commission of Ireland. So Charles, really looking forward to your presentation and you're very welcome.
Well, great. Thank you very much. And I'm really delighted to be here. And thank you very much for the invitation. And just to say, in terms of accessibility, one of my big deficits is that I speak too fast. So please tell me if I am speaking too fast. And that's also complicated by the fact that I'm originally from County Kerry, the best county in Ireland. So sometimes it can be a little bit difficult to understand me. So if you need me to slow down, please do tell me. I'll do my best to go slowly, but I do get carried away sometimes. So please do flag if I'm going too fast.
Thank you, Charles. That's very good to know. I'll message you if we need to, but I wouldn't worry about it. You sound like a great speaker, so really looking forward to this.
Great.
Good luck.
Thank you. Okay, so I was asked to really speak about understanding and applying your rights in the context of education. So I'm really going to be talking about reasonable accommodation and inclusive education. And it's really important. It's a really important right because we know that persons with disabilities face very significant barriers globally to accessing education and progressing on to higher education, to university and to further training and vocational training. And that has very significant consequences in terms of poverty, in terms of accessing the jobs market, and having the money to lead a good life. So education is really important, and it's important that we understand our rights in respect of accessing education and understand the duty around reasonable accommodation. So I have divided this presentation into kind of 7 main parts. So I'm going to talk very briefly at the start about sources of law. I'll talk a little bit about the UN Convention on the Rights of Persons with Disabilities. And just to say in relation to that, I know that Delia will be speaking later today in relation to the EU and the UN Disability Convention, so I won't go into too much detail, but it's a very important source of law and it's a very important framework that we need to be familiar with. I'll talk then specifically about the Irish legislation, the Employment Equality Act, the Equal Status Acts, and I'll talk about the notion of discrimination and access to justice, and we'll have a discussion around some case studies. That's really just the kind of the broad overview of the presentation. So I thought I'd start with a quotation on really reasonable accommodation by Sandra Friedman, who's a really prominent feminist researcher and a kind of philosopher and really important person in this area. And in this book that she wrote called Disability Equality, a Challenge to the Existing Anti-Discrimination Paradigm, she talks really about the importance of reasonable accommodation for persons with disabilities in realising equality. And just to quote her here from the book, she says, instead of requiring disabled people to conform to existing norms, the aim is to develop a concept of equality which requires adaptation and change. So really what she's talking about is reasonable accommodation. And I don't want to get into too much kind of detail around different theories of equality, but we have moved from a theory of formal equality, which took a very reductive review of what was required to ensure equality, from trying to take a very much a colourblind or a gender-neutral approach to challenging exclusion or discrimination, to one of substantive equality, which is to understand that society and structures within society pose additional barriers, and that you need to take a more holistic approach, for example, in the context of disability, providing reasonable accommodation. So I just wanted to point that out first. And the other thing to say is that I'm going to be talking about anti-discrimination or non-discrimination laws, and these have become very prevalent in countries throughout the world. In particular, I'm thinking about common law jurisdictions like Ireland, the United Kingdom, Canada, the United States, where they have included non-discrimination across different grounds, including disability. But actually, if you look at the research on anti-discrimination and non-discrimination laws, you will see that there is a limitation to their effectiveness. So they provide a redress when you're less favorably treated or discriminated against, but very often it's timely. It takes a long time to take a case using the legislation. It can be very expensive. You may not be successful, or it may not give you an adequate remedy. So there are limitations to anti-discrimination law in terms of what it can achieve around changing attitudes and removing barriers. I'm going to start off with talking about sources of law very briefly. I teach a module on Irish legal systems to first year, so I spend a lot of time every September and October talking about the different sources of law. But it's important that we understand that there are legal rules that are very important, and there are origins of these legal rules, and these inform our legal system. And we need to understand those rules if we are to know what they are, what our rights are, and how we're going to apply them. And one of the kind of difficult things sometimes is that you'll have different sources of law, and that you have to figure out, well, where can I go to, what law applies, or what law can I use to best advance my claim. And we also need to understand that law happens within a framework. So we have a legal system that categorizes the different sources into different categories. And I'll talk about that in a moment. But we really have four main sources of law. We have the Irish Constitution from 1937. And we're a common law jurisdiction here in Ireland. So we have case law, we have common law, and then we have lots of different pieces of legislation. And then we also have, as a really significant piece since the 1970s, as part of our legal system, is European Union law, which can apply through different methods, including regulations and directives that have to be transposed into Irish law. The other kind of there's other sources of law then as well, but one of the really important other sources of law are international law. For example, the UN Convention on the Rights of Persons with Disabilities, which I will talk about. So what are the sources of law that are most important for persons with disabilities? Well, probably one of the most important ones from an international law perspective and it definitely is the most important one, is the UN Convention on the Rights of Persons with Disabilities. And the drafting of that happened in 2006. It opened for signature in 2007. It's a very successful treaty in terms of states, parties, international jurisdictions signing up to it. And that opened, it commenced in 2008, and then from 2011 onwards, the UN Committee on the Rights of Persons with Disabilities has been holding states to account by checking their compliance with the convention. So I'll talk a bit more about that in a while, and Delia will talk more about that in the afternoon. You also have European Union law, which has expanded its scope, which Delia will talk about over the course of the creation of what was in the European Economic Community. And the EU actually was involved in drafting the UN Disability Convention, and it acceded to it as well. So Delia will give you a really interesting taste of that whole area later on. The European Convention on Human Rights is very important as well, and particular for civil and political rights. That has relevance in Ireland now, particularly since it was incorporated into our legal system. So what happened in 2003 was that a piece of legislation was introduced called the European Convention on Human Rights Act 2003. And that piece of legislation was introduced at a sub-constitutional level, which recognises the rights set out in the convention. And if we are taking a case to the High Court where we're saying that our rights are being violated, we can make arguments before the High Court now using the rights contained in the European Convention on Human Rights. Now, there's two different sources of human rights, which you might have heard of before. You have civil and political rights, which are, for example, the right to life and the right to privacy, the right to liberty. They're civil and political rights. Then you have economic, social, and cultural rights, and they're very important rights. They have to do with things like the right to health, the right to education. They're economic and social rights. The cultural rights, the right to participate in the cultural life, sport. They're all economic, social, and cultural rights. And the reason why I'm telling you there's two different kind of broad categories of rights is because civil and political rights, the right to life, the right to privacy, or for example, the right to vote, there's an immediate obligation on the state to respect those rights, whereas they're under international human rights law, socioeconomic rights are subject to a concept called progressive realization. So there's a discretion given to the state in terms of how it uses its resources, because there's very, limited resources to fund healthcare, for example, or fund education, and there is more leeway for them there to realize those rights. So we have very strong protection in Europe and by extension here in Ireland around our civil and political rights under the European Convention on Human Rights. But then we also have the European Social Charter, which came out in the 1960s and was revised in 1999. And a lot of people actually don't know about that, but that actually tries to address the gap of protection across the Council of Europe and the 47 member states of the Council of Europe for the protection of socioeconomic rights. And there is a European Committee on Social Rights that examines state reports, and you can make complaints there as well. And they examine national practice, and they look to see whether states are complying with the European Charter. It's much weaker than the European Convention on Human Rights, but it is there, and they have some important cases decided on education. But then in Ireland, then the other really important pieces, the other really important sources of law are legislation, which I'll talk specifically about, the anti-discrimination legislation, and case law. And I'll talk a little bit about case law. I won't give you too many cases, but that's a very important source of law. Is everybody with me? I'm not putting anybody to sleep yet.
No, not at all. This is really, really good. Thank you, Charles.
Great. Well, I'll move on now to talk about the UN Convention on the Rights of Persons with Disabilities. And myself and my colleagues here in the Centre for Disability Law and Policy here, and my colleague Dr. Siobhan Quinlivan, who is the leading expert internationally on inclusive education, have done a lot of work across lots of different parts of the UN Convention on the Rights of Persons with Disabilities. And Ireland signed the UN Disability Convention in 2007. And actually, Ireland was a real champion of the UN Disability Convention. With Mexico and other countries, they really pushed it. And it was Mary Robinson, when she was the UN High Commissioner for Human Rights, she had commissioned my colleague, now the UN Special Rapporteur on Disability, Professor Gerard Quinn, who was here at the university for many years, to do a report with Professor Tressa Degener from the University of Bochum in Germany. And they, in 2002, published a report which really established the evidence base that persons with disabilities, while all human rights applied to them notionally in an equal manner, people with disabilities were not seen as rights holders. They were facing huge systemic exclusion from society, barriers participating and enjoying their rights across the whole spectrum of human rights, civil and political, economic, social and cultural. So they made a very good argument for a specific UN Disability Convention, and it took hold. So we were very much a champion of it. Gerard was very much involved in that report. He co-authored it with other colleagues from Ireland and elsewhere. And then you had Mary Robinson pushing this agenda when she had taken up that position with the UN. And then we quickly signed it in 2007 when it opened, and we were the last EU member state to ratify it. So that's a matter, I think, of disappointment, I think, for people involved in the disability rights movement, in particular persons with disabilities from Ireland who are champions and human rights champions globally. They're very disappointed with the lack of commitment to ratification. It eventually happened in 2018. And the delays, I think, from government in ratification, their explanations were less than satisfactory. I won't get into it too much, but it's very unfortunate. So there are significant consequences to non-ratification, because it means that you delay your reporting cycle. So once you've ratified, you enter into a reporting cycle where you have to come before the committee that's been set up from Article 30, under Articles 30 to 33. There is a mechanism whereby a committee now, a UN treaty monitoring body, checks on state parties to see whether they're living up to what they said they are living up to by ratifying the treaty. And we haven't reported in yet because we were very late in ratifying. So that will happen. So there will be an account of Ireland's compliance with the various different rights in the convention. The other thing to say as well is that, and I think this is important for those of you that are involved in advocacy, is that Ireland hasn't ratified the optional protocol to the convention. And what the optional protocol does is that it says okay, we're signing up to additional measures. So the committee that monitors compliance can also hear complaints from people when they've exhausted their domestic remedies, they've tried to resolve their rights dispute with the state domestically, and they didn't get anywhere. They can go to the committee for and make a complaint. Or in the case of the UK, which happened, the first inquiry, if there is evidence of systemic violations of the rights of persons with disabilities, the CRPD committee can come and do a state visit and they can write a report. And they did that in respect to the UK because the UK had really implemented austerity measures. And what I mean by austerity is they cut public services and public spending after the last economic downturn. And those cuts disproportionately affected persons with disabilities, and there was evidence that people actually died, and that's what the committee found. So the fact that Ireland hasn't ratified the optional protocol, I think, is a matter of much regret. It's shameful. And I think in your advocacy, when you're speaking to politicians and other really, I suppose, government, I think you should highlight that as an issue that needs to be resolved immediately. So the UN Disability Convention then, just to say that it sets out in its main body in Articles 9 to 30 a set of rights. And these rights, I loosely categorize them rather than going through all 20 plus of them. I've loosely categorized them into the following headings for you. So you've got a category of rights around the protection of the person. You've got a category of rights to restore autonomy, choice, and independence, because people are often with disabilities are segregated in institutional settings globally, including in Ireland still. Rights of access and participation, for example, the right of access to justice under Article 13. And then liberty rights, and then also economic, social, and cultural rights. And I would include the right to education within that category because it's a socioeconomic right. So really, there's nothing new. Well, theoretically, there's nothing new in the convention. It basically restates the existing body of human rights, but animates them and explains them and how they apply to persons with disabilities. And that's what's really innovative about the UN Disability Convention. So it's in that context then that I bring you to 2021. So Ireland ratified the convention in 2018, and then it entered into the reporting cycle. Now it hasn't come before scrutiny before the committee yet, but they issued their initial report in 2021, and they were saying, well, look, we're broadly compliant with our obligations under the convention. That's what state parties do. They say, look, we've done this, that, and the other. We're doing great. And then you have shadow reporting from disabled persons organisations, the National Human Rights Institution in Ireland, that would be the Irish Human Rights and Equality Commission, and other stakeholders will say, well, actually, there's massive problems across these areas. So they will do shadow reporting that will put the very positive report from the state into context. But this is just taken from Ireland's initial report, which puts a very positive spin on actions around disability and compliance with the convention. And what the state said was that Ireland has robust equality legislation and a significant legal framework to protect human rights. Persons with disabilities are equal citizens in Irish law. Discrimination on the grounds of disability is prohibited under the Equality Act, so I'll talk about those. The areas covered by the acts include employment, education, and the provision of goods and services. And what I will say to you is that, yes, those laws are in place, but they do not, particularly on the Equal Status Act, which covers non-discrimination accessing education. My view and the view of others who do work in this area, including my colleague, Dr. Siobhan Quinlivan, is that the Equal Status Act does not comply with what's required by the UN Disability Convention on Reasonable Accommodation and Non-Discrimination. We'll talk about that. There was a report published, I think it was last week or the week before, by the Joint Committee on Disability Matters, and they actually took a look at all of our legislation in Ireland, and they were critiquing it from the perspective of the UN Disability Convention. And this is just a relevant piece to what I'm talking about today. They said there is a need to review the Employment Equality Acts and the Equal Status Acts with regard to intersectional discrimination. So that's, people with intersecting identities that are protected grounds under the Act. So, for example, a person with a disability who's maybe transgender, or somebody who is a traveller but also has a disability. And they go on to say, and how an individualized approach can be strengthened to assessment under reasonable accommodation process, consideration of funding under the Equal Status Act for those with limited resources, and an amendment to provide the denial of reasonable accommodation is discriminatory is also necessary. So they're identifying problems with the current legislation, and they also say that exemptions to the prohibition of discrimination in the Employment Equality Acts and also needs to be reviewed, particularly the removal of Section 35(1) on different rates of remuneration for disabled people. So anyway, look, what I'm saying here is that we have good legislation, but it's not perfect and it needs to be strengthened, and particularly in respect of students with disabilities, particularly I think also in higher education, it's not sufficient. So what is the anti-discrimination framework in Ireland? Well, we have the Employment Equality Acts 1998 as amended, and we have the Equal Status Act 2000 as amended. So they are important sources of law. They really would be seen as the anti-discrimination framework in Ireland. Now, the reason why there have been so many amendments is that it's important that we keep the law up to date, but also Ireland got out ahead of the European Union. So the European Union brought in a framework directive on employment and a race directive in the 2000s, but we had already at that stage enacted the Employment Equality Act in 1998 and the Equal Status Act in 2000. And they've been amended to give effect to that. And there's more amendments coming down the tracks now because they're extending. They really had only looked at employment in respect of persons with disabilities. Now they've extended it, and Delia will talk about this, into accessibility for goods and services. So there's more changes coming down the tracks for us. So you can see here the important interplay between national legislation and EU law. So I'll leave it at that, but I'll talk more about the Equal Status Act in particular, and I will refer to the Employment Equality Act as well. But they are the two pieces of legislation that allow us, if we are discriminated against, if we are as I am, as somebody who is in one of these minority groups, I am able to, if I'm discriminated on the basis of my sexual orientation, I can take an action under the Employment Equality Act or the Equal Status Acts, or as a person who is under the Equal Status Act, if you be discriminated against on one of those protected grounds, you can take an action. Can I actually ask you, can you identify the other protected grounds other than disability in the Employment Equality Acts and the Equal Status Act? Do you know what they are? Does somebody want to suggest a couple of grounds that are covered?
So we have some in the chat here. We have gender, family status.
Yes.
Family, community,
Yep.
race,
Yep.
religion.
Yeah.
Age actually
Yes.
is another one.
Yeah. Yeah, that's great. So there's 9 in total. Yeah. So there's a whole range of minority groups and people that are at risk of less favorable treatment in employment and accessing goods and services that are provided for, that can have recourse to the employment equality legislation to take a case. Now to the Workplace Relations Commission. It used to be the Equality Tribunal. It was subsumed by the functions of the Workplace Relations Commission a number of years ago. Now, I want to talk very quickly about this case. It's called Nanonagel and Daly, and I think it's a really interesting case because for me anyway, it sums up the difficulty in litigating around reasonable accommodation. And the case involved a woman who was, her name was Marie Daly. She was a special needs assistant, and she worked for a school that provided educational services for children with disabilities in Kerry. And she had worked there since 1998, actually. And in 2010, so 12 years, she'd worked there for 12 years. She was in a car accident, and she received very significant injuries, and she was a wheelchair user. She was using a wheelchair then after that as a result of the accident. And she had made great recovery. She had gone through a period of rehabilitation, and she was feeling better, and she sought to return to work. And really, in essence, the school didn't want her to come back. The principal didn't want her to come back effectively. And the other special needs assistants didn't want her to come back because she was able to do some of her previous role, but there were certain tasks she wasn't able to do. And they never really consulted with her. They had RIDE and occupational health assessments, and she was very disappointed. So she sought legal advice, and she was told, well, look, actually, you can take an action under the Employment Equality Act. And that's what she did. And I wrote an article about this case with my colleague Siobhan Quinlivan called in the Northern Ireland Legal Quarterly. It's available for free download if you want to read it. But it really was just a discussion of a saga of litigation, because this case went on a very long time. It actually started in the workplace. It started in the Equality Tribunal. It's now called the Workplace Relations Commission. It then went on appeal to the Labour Court. And then it went to the High Court. Then it went to the Court of Appeal. And then it went to the Supreme Court. And then it was subsequently sent back from the Supreme Court, once they gave their judgment about certain aspects, to the Labour Court. So really what I'm saying about this case, it's a very interesting case in and of itself, because the Supreme Court made very important statements around the duty of reasonable accommodation for employers. And I suppose a key implication of the Supreme Court's judgment is that reasonable accommodation can entail the redistribution of duties. So in this case, the woman was coming back to work, she couldn't do some duties, and they said, yes, reasonable accommodation can entail changing the duties that the person does to accommodate them. So they gave a couple of very interesting statements about EU law that's relevant here. And they also, Justice McMenamin, who's now retired from the Supreme Court, he did reference the UN Convention on the Rights of Persons with Disabilities in his judgment. And I think that opens up the potential for the UN Disability Convention to be used to a greater extent when the superior courts are interpreting our Irish employment law. But the reason why I point up this case is really because it highlights the difficulty in litigating. This woman ended up, in being involved in litigation for over a decade. It went on appeal and appeal and appeal. Now, most cases that won't happen, but it does point to the challenges, and I'm sure that took a toll on her having to take all those cases. But it's a very important judgment, and it does have relevance and important implications for employers, including the duty to assess and to consult with the employee about redistribution of duties, as it was the crux of that case, really. So I'm asking really, why is this relevant? It's why am I talking about the Employment Equality Act? So why am I talking about the Equal Status Act? It's very important because it imposes legal obligations. And the reason why I'm talking about why I'm making reference to EU law and the UN Disability Convention is that the CRPD takes a much broader understanding of reasonable accommodation than we have in our own legislation, in terms of failure to reasonably accommodate is discrimination. And I think that is really having an influence here domestically. And there is a recognition that we need to improve the 1998 Act, the 2000 Act as amended, to better protect people's rights and to give a more robust protection for employees' rights, but also the rights of people accessing goods and services. So I'm now going to talk about what is reasonable accommodation. I know you probably have a good sense of this already, but really, reasonable accommodation is about discrimination. And when somebody is accessing goods and services, or they are seeking employment, if they're being treated less favorably by the employer, or they're refusing to make an adjustment to allow that person undertake a job or access a good or service, it is discrimination. And really there is an obligation on the employer or the service provider to take a look at the individual personal circumstances of the person. And I think sometimes employers and service providers, they think, well, we provide this type of access, so this is how we approach accessibility. But they don't understand that really reasonable accommodation is about having a conversation with the person that's looking for an adjustment. So, for example, a student who needs a particular change or accommodation to effectively participate in the educational program. And they think, well, we have an accessible learning environment online, Blackboard or Canvas, for example, and that's sufficient, whereas the student might need something different. The CRPD committee they've made very useful statements on this. They've had a general comment, and they've been very clear in their concluding observations to states that there is a duty to legislate to ensure the reasonable accommodation provisions are enshrined in law. We have them, but they're not very strong, particularly on the Equal Status Act, on accessing goods and services, including educational services. And what they have said is that these laws should ensure that reasonable accommodation is recognised and punishable form of discrimination, so that there's consequences where an employer or a service provider of goods and services do not provide for reasonable accommodation, or they don't do the assessment. I think I might just give you an example of one case. It's quite a well-known case, and it was taken by a mother on behalf of her son to the Workplace Relations Commission against a board of management of a school. It was in around 2006. And can I ask you, have you ever heard this case? It's about a pupil in sixth class. They were attending a national school. He had obtained a dog from the Irish Dogs for the Disabled, and the particular pupil had mobility and stability issues related to a medical condition. And this dog actually was a support dog, which would have minimized risks around tripping and falling and supporting this particular child. And the parents had several meetings with the school about it and the school principal. Have you heard of this case? Can I just ask you, has anybody heard of it?
I haven't, but I'd love to hear a bit more about it
Yeah.
If you're going to tell us.
Yeah.
That sounds really good. Yeah, tell us. Interesting.
Yeah, it's a really interesting case. So the teachers were very supportive about the dog, the benefits the dog would bring for the student and for the classroom, but the principal had reservations about it, and the principal basically ruled it out. He said the dog can't come in; it's going to be distracting the other children. That was mainly, I think, the evidence was that was the main concern. So the pupil and the mother actually won the case, and what the Workplace Relations Commission found was that there was a prima facie case. So on the face of it, there was discrimination on the grounds of disability, contrary to the Equal Status Acts under Sections 4 and Section 7. So what they did was they had this finding of discrimination, and they awarded compensation of €5,500 on the grounds of disability. Importantly, then they ordered the school to redraft their policy regarding assistance dogs and to ensure that they were in compliance with the Equal Status Acts. And they also made the suggestion that the school should engage a disability consultant in relation to that. And then a report on progress of the policy had to be made to the Irish Human Rights and Equality Commission 1 year after the date of the decision. So that's actually a really, I think, good case to show where you have an attitudinal barrier by a school, in this case, a principal who yields the power, and the fact that the mother and her son were able to take the case to the Board of Management. Now, can I just say again, that sounds all very well and good, but this took years to come to a decision. So at this stage, this boy had gone on to secondary school, and this happened years previously. But nonetheless, it was an important judgment which highlights the fact that schools have to reasonably accommodate students with disabilities. So I just put that out there as an example of a good case, but just to illustrate the points. Now, I'm criticising the Irish legislation because I don't think it's very good in some ways, and I'll talk about that why in terms of the obligation. But the UN Disability Convention provides that accommodation means necessary and appropriate modification where needed in a particular case. These are very legalistic terms, and that's what it says. And under the Employment Equality Act, the employer is required to take appropriate measures where needed in a particular case to enable a person to access, in the case of my presentation today, access education. Okay, so under the Equal Status Act, a service to do all that is reasonable to accommodate the person's needs. Now, under the Equal Status Act, I think it's important to note that the requirement of reasonable accommodation isn't a right at large. And what I mean by that is that there isn't an obligation on the service provider, the university or the college, for example, to pay for, if not to have consideration of the cost. And there is a caveat to the duty, which is that of nominal cost. If you contrast that with the Employment Equality Act, it's a disproportionate burden. Now, I won't get into this because I could talk about it for hours, but unfortunately in 1996, the Supreme Court was referred a case from the president around an earlier version of the Employment Equality Act 1998. I'm not going to get into it, it's a bit complicated. But very unfortunately, the Supreme Court gave a judgment which on reasonable accommodation and the cost of it for employers that is very troubling and has complicated the legislation in this area as a result ever since the mid-90s. As a result of that, the requirement on providers of goods and services is nominal cost. Now, can I ask you, what do you think a nominal cost is? Well, you know, if I was to say to you the University of Galway, anybody here from the University of Galway? Can I ask?
We have a few hands being raised.
Few hands
Michelle,
being
I see you
raised. Okay.
raising your hand.
Okay, well, if I was to tell you that the University of Galway nearly had 70 million euros in reserves, in its financial reserves, so it's got money that it's invested with a wealth manager in a UK bank. And if I was to tell you that the University of Galway said that it wasn't going to reasonably accommodate a student who needed, for example, Irish Sign Language, right? It could be very difficult for the University of Galway to do that because they have a lot of resources. They have a lot of students. They have over 20,000 students. They've got over 3,000 staff. So what I'm saying here to you that even though the legislation is quite poor in terms of it says nominal cost, that can undermine the provision of reasonable accommodation. So clearly, what is a nominal cost for a small business or a small educational provider? If they have less resources, the duty isn't, you mightn't prevail with your case, is what I'm trying to say, really. If it's a small employer. But if you've got a large employer like the University of Galway or another Irish university that's well resourced, that has multi-million euros in reserves, it's very difficult for them to say that, oh, it's we can't pay that. The cost is too significant for us. So really, when I'm talking about reasonable accommodation, I'm talking about a positive legal duty. So a student will come to a provider of education services, a university, and they'll talk about the reasonable accommodations that they require. And then the university will consider what accommodations it will be able to put in place. Now, for employment, it's a disproportionate burden, a nominal cost in relation to the Equal Status Acts for education. So really what I'm trying to say here about it is that it's very much a tailored approach. There is a duty to consult with the student or the employee if it's under the Employment Equality Act to see what they require. And I think that's where a lot of employers and service providers fall down. They don't have that conversation. They don't properly consider it. And they need to consider what they can do. And generally, it's a reactive duty. So a student is coming to you, they're saying, okay, I need to be reasonably accommodated. And then you say, well, okay. And most universities now will have a good policy on this. They will have a disability support service. They will come through with a report that will instruct the various different schools and programs on how to reasonably accommodate the student in terms of participating in lectures and other activities and exams. So it's a reactive, but in some cases it will be a preemptive duty. And I'm thinking particularly in relation to students who might have done an undergraduate degree and they're coming back to do a master's. Well, clearly then the university should have a good sense of what is required to support that student because they would have been through a process of assessing their needs and reasonably accommodating them previously. I think it's really important to have a dialogue between the duty bearer, so the employer or the service provider, the education institution, and the person with a disability. And that was one of the interesting things in the Nano Nagle case, is that there was a lot of conversation around there was different perspectives along the route of that case about whether or not the fact that the principal hadn't properly consulted with the woman in that case, Marie Daly, who wanted to return to work. Now, the principal had consulted with the other SNAs, and the other SNAs were going like, well, we don't want her back because we don't want to take on any of her work. So she was the principal in that case was willing to consult with the other employees that were affected, but not with the employee themselves. But I think it would be a very unwise employer that wouldn't have that conversation with the employee or with the student to assess their needs, because then they will really be opening themselves up to criticism and a finding of failure to reasonably accommodate and discrimination under the Act. So like I said, it's an individualized duty, and my big criticism of this in terms of the Equal Status Act, which affects students with disabilities, is that the whole notion of nominal cost is in there. And I think if you're engaging with this at an advocacy perspective, I think you should be arguing for a removal of that and an alignment with the Equal Status Act, and for an enhanced obligation on service providers to provide accommodations. When the service provider or the employer is looking at what is a burden, what is a nominal cost, what is a disproportionate burden, they're going to have to consider the cost, the structural burden, the disruption, the benefits, and also whether there's any public funding available to them to reasonably accommodate the student or the employee. Now, the other thing I wanted to say here was that sometimes, and you'll hear this a lot, that providing a reasonable accommodation to a student, particularly in the context of exams, actually, so extra time, for example, or other accommodations around assessments, you might hear lecturers saying, well, that's unfair to other students, or you might have students sometimes say, well, that's not fair, they're getting extra time. And that really doesn't factor into it. It's not concerned about what somebody else thinks as a lecturer or another student who are saying that I'm being less favorably treated. This is about addressing the needs of the person with a disability who is availing of the educational supports, or who needs reasonable accommodation. So that does not factor into the conversation about that person's reasonable accommodations. And there is pushback in relation to that, and it's important to be very clear that that is required as the duty to reasonably accommodate, and there has to be an assessment of it. Now, like I said, I don't want to get too much into the technical detail of the legislation, but like it's really weak for a number of reasons, the legislation, and it doesn't, in my view, comply with what's required under the UN Disability Convention. So discrimination under the Act is, if without such special treatment or facilities, it would be impossible or unduly difficult for the person to avail himself or herself of the service. And then the nominal cost is a big issue there in relation to the service provider. Now, I did put down here disappointing decisions. There have been some disappointing decisions, but maybe I should also point out there have been some important decisions in relation to the Equal Status Acts as well, and that even despite the fact that the legislation is quite weak, for example, that case I talked to you about, a mother and her son and the Board of Management from 2016, that really takes a very progressive approach to holding the Board of Management for that primary school to account around not providing the accommodation. And that really was an attitudinal barrier, a block by the principal in that case. So what I'm saying that there are, it's disappointing that the legislation hasn't been updated to reflect the requirements of the CRPD. There is an opportunity, particularly with Ireland reporting into the UN Disability Convention now, as part of the reporting cycle. I don't think there's a date for that yet, but when that does happen, there will be an opportunity for the committee to make recommendations to strengthen the employment equality legislation. I hope that is there when they come to consider it. I'm sure the Irish Human Rights and Equality Commission will raise that amongst other stakeholders. I've been doing some work recently on access to justice for the Irish Human Rights and Equality Commission in respect of persons with disabilities, and the report that I produced should be published hopefully later this year. But I did a large qualitative piece where I interviewed 27 key stakeholders, including persons with disabilities. And one of the things that really kind of, I suppose I always knew this, but the extent of it I hadn't really appreciated, was that the people that need access to the justice system the most, because they face the most discrimination, are arguably persons with disabilities, yet they face the most barriers in accessing the justice system. And I think that is very problematical. And Article 13 of the UN Disability Convention provides for a right of access to justice for persons with disabilities. And I'll point up in this regard is that if you want to take a case to the Workplace Relations Commission, what you'll be told is that, yes, you can do that. It's a quasi-judicial environment. You don't need legal expertise to take the case. But if you're taking a case against the university is going to be represented by a solicitor and by a barrister. If you take it against an employer, they will have a solicitor and barrister, or they will have IBEC representing them. So there's a really inequality of arms here, because legal aid isn't available. Legal aid, unfortunately, isn't available to people under the Employment Equality Act. And I would argue that the current review of the civil legal aid system that the minister has ordered That should look very closely at this. And I believe, in my view, that for access to justice under Article 13 to be realised, there should be consideration of allowing legal aid for people who are taking their cases to the Workplace Relations Commission to support them in taking those cases, and that should be funded for under the legal aid schemes. In my view, it's a big barrier. It's so daunting to go into the Workplace Relations Commission to stare down an employer or a service provider who you are saying has discriminated against you, and they're very well represented, and you're in there by yourself trying to make sense of the legislation and make arguments to say that your treatment amounted to discrimination under the Act. It's a very difficult thing to do. So I want to end on it with a couple of case studies, and I want to really hand over to you on this. So the first one is, I want to ask you, what would you do? You have a student who has a LENS report which suggests that an accommodation should be made to allow that student to record the class so they can listen back and that they can learn and benefit from that. And you have a really cranky lecturer who doesn't like students recording in class. They have a bad attitude, and they say, "Okay, you have a LENS report, but I don't allow anybody to record my class. You're not allowed to record." What would you do in those circumstances? Can I ask you, over to you, what would you do?
At the University of Galway, we have different protocols that, different things, different steps. And if the lecturer will not accept your LENS report, we always encourage students to get it in writing. Get them to put it in writing that they don't allow anybody in their class to record, and that he's aware. And then you take it to the board. Údarás Óscoil. There's different people that you can speak to on the board and explain your situation, and of course work with the disability service within the university.
Yeah, that's a really good answer. And actually, there's no right way to answer it. There's loads of different ways you can do it. But what you're suggesting is actually a very good way to deal with this. So I would say put it in writing. Yeah, that I would actually write to the lecturer and I would say, "I note that you told me that I cannot record in lectures." So they mightn't respond to that, but you put it in writing so you have a record. Talk to the student union, talk to your class advisor, talk to the program director, talk to the head of school. There's loads of people you can talk to. You also have a function within universities around equality, diversity, inclusion. You also have you have class representatives into the student union. So there are lots of ways in which you can challenge that discrimination. And that does actually happen. There's a huge emphasis now on inclusive education, on universal design for teaching. But yet you can still come up against these barriers and you need to challenge it. And there's loads of different ways. And you're absolutely right. I hadn't thought about Údarás na HOllscoil, the governing authority, they can do it. Also look at the policies. There's grievance policies. There's a student complaints mechanism. So you can formalize this as well internally. So there's loads of different ways you can challenge it. And you can also then take a case to the Workplace Relations Commission. But those initial steps, I would say to you, the student grievance procedures, talking to those different stakeholders are going to bring about a change much more quicker for you. Because bear in mind that your degree is 3-4 years. This might happen in 4th year. You might be doing a master's, which is 1 year or 2 years part-time. These things are difficult to resolve quickly. So, if you're going through the legal route, but that is open to you as well.
But I do believe that even if it's only 1 year, without your LENS report being accepted, that student might end up not getting a first, might get a third, because their LENS report has not been accepted.
Yeah.
Or not, a number of lecturers never put anything up on Blackboard, okay? When lockdown happened, they had to learn to do it. So now there's no excuse. They can do it. And they must do it.
Yeah.
So it is a case of, it doesn't matter whether it's only for 1 year or in your last year. Use those mechanisms, because you're the one that's going to advocate for yourself. You don't have a rider on a white horse that's going to come along and save the day. You have to self-advocate.
And you also have the student union to support you in that as well,
Yes.
you know,
Yeah.
and that's very important. And also the disability support service, in my experience, certainly, they really are champions for students' rights, and that's very important. And you're right, some people are terrible with technology, but you know, a colleague or a learning technologist can support that lecturer that cannot use Canvas or Blackboard to use it, and they should be made to do that. And you do that by raising the query with the multiplicity of stakeholders, including that person's line manager, who will be a program director or a head of school or head of discipline. So there's so much you can do. Can I ask you for the second one? I'm conscious now that I'm going over time. A student with a particular technology use a particular technology as a reasonable accommodation. The lecturer sees the technology being used in class and asks the student in front of the class, what are they going to do? What are they doing? What are they doing not to use it? It's disrespectful to put it away. What would you do in that class if you're confronted with that? You're saying, well, what are you doing? Are you recording me? You're using that technology. Don't use that. What would you do in those circumstances? So, for example, you have a recorder to record lectures, and the lecturer
Yeah,
calls you.
someone in the chat saying they would probably cry, which is
Mm,
fair
mm,
enough. I don't know what personally I would do. I feel like I'd be quite taken aback, and I wouldn't
mm,
be ready in the moment to respond
mm.
to something like
Yeah,
that.
yeah.
It's very it's kind of almost an attack in a sense, because it's very
Mhm,
investigative, I suppose, and putting you on the spot in front of people.
mhm. Yeah. There's no one way to respond to that. You could say nothing. You could say, I have a LINS report, if you feel comfortable saying that. But after that scenario, you need to challenge it. You need to, if you don't feel comfortable talking to the lecturer, you can talk to the student union, your class rep, the head of school. Also, there's lots of structures now. You know, there are people in schools and disciplines that have responsibility for learning, teaching, and assessment. You do have people in every school and college in the university who have responsibility for equality, diversity, and inclusion. You know, every university now has to get a certain number, has to be accredited for having an Athena Swan accreditation, which is around really focused on gender equality. But that's the reason why universities are seem very committed to equality, diversity, and inclusion, because if they don't achieve these accreditations and they don't have good processes and procedures in place, they're cut off from research funding. So there's a real stick and carrot approach to actually ensuring good governance within universities, compliance with equality, diversity, and inclusion, the public sector duty under the Irish Human Rights and Equality Act. So there's lots of things you can do, but don't ever feel you need to disclose your disability, and you can deal with that situation after the moment. But I can imagine something like that is very traumatizing, very upsetting, and there's no one way to react. But you can react, and you can take issue with it, and you can challenge it. And we need lecturers, we need everybody to do better to create the right environment for inclusive learning. So I have another example, but I'm going to end there because I'm conscious I've gone horribly over time, so I apologize for
I
that.
haven't gone horribly over time. Don't be silly. That was absolutely incredible, Charles. I can't thank you enough. That was so informative. I really think your examples that you used were really beneficial. I really just thank you so much. Yeah, wow, blown away.
I'll stop watching.
Thank you.